It was filed yesterday. I got a filing number.
Day after tomorrow, Thursday.
Day after tomorrow. Obviously.
Maybe your Lordship. Lordship, I'd like to mention item number 5, Lordship. In this case, Lordship, my senior has some personal difficulty for. Only for their Lordship.
Okay.
Deeply obliged.
Wait, please, Lordship. I beg to mention item number 6 and 8 from the supply list, Lordship. Kindly pass over this matter for the day, Lordship.
Okay.
Master, please.
May I please, Your Lordship, I beg to mention for the listing criminal petition for withdrawal on 18.
For tomorrow. Bro. Take your seats. Heard Mr. FPR, counsel appearing for the petition. And Mr. P. Sharma, additional public prosecutor assigned for this role of the part. By this application under section 483 PNS is filed on 0306/2025, petition in the wait for his wait. In special, green bucket NA narcotics. Case number such and such. 03 green bucket PGN, 43025. Arising out of Pomano, case number 87 of the 2004. Under section 21 of the C of the NDPS Act. The trial of which is presently pending before the court of the special judge, green bucket NDPS. In which he was arrested on 26/07/2024 and is in custody since then. The contention of the petition is that while he was arrested on 26/07/2024, the connection with Bongaigaon JIPS case number such and such, the authorities concerned did not comply with the provision of section 47/48 of the PNSS. Did not inform him the reasons and grounds of his arrest. They submit by the petition that in terms of the decisions of the Honorable Supreme Court in the case of he has entertained. Peruse the records of the case. It is seen that as per the FIR, the prosecution's case is on the night of 25/07/2024 around 11 PM. On receipt of specific information, police personnel from Bongaigaon JIPS proceeded to the platform number 1 of the new Bongaigaon junction and intercepted the petition on the intervening night of 25/07/2024 and 26/07/2024. On reports number B4 of Obod Assam Express within bracket DBRG, that's LGH, bracket close. Town DN capital, train number 15909. And recovered (26) numbers of soap cases, along with a Vivo mobile phone, where the soap cases contain forgery substances suspected to be heroin. After his arrest on 26/07/2024, he was produced before the Special Magistrate Bongaigaon on 27/07/2024. It is put on 26. incident in judicial custody. It is also seen from the record that the FSL report dated 22/10/2024 confirmed the seized substance recovered from the possession of the conscious possession of the petitioner to be heroin. After completion of the investigation, Sarsit and said, Bongaigaon JPS case number 87 of the 2024 was submitted against the petitioner on 19/11/2024. Against the petitioner was submitted under section 21 within bracket C and DPS Act against the petitioner. After filing of the charge sheet, said Bongaigaon JPS case number 87 of the 2024 was re-registered as special within bracket NAR, AR small bracket case number 03 within bracket PGM of 2025 before the Court of Law and Special Debt in bracket NDPS. Bongaigaon from Session Judge. Bongaigaon Session Judge Bongaigaon. Cognizance of the offense under section 21C was taken by the Court of Law, Special Judge NDPS 06/01/2025. And charged under section 21C NDPS of frame against the accused petitioner. But it says special court on 01/02/2025. Case record reveals that as on (14/05/2025), out of 7 named prosecution witnesses in the charge sheet, prosecution have adduced evidence of 2 of its witnesses who were thoroughly cross-examined by the defense. From the records of the case, it is also seen that the police authorities of Bongaigaon JRPS duly complied the provisions section 50 of the NDPS Act. Informing the petitioner that he is in possession of the materials position of NDPS Act. And accordingly, search was made and the NDPS items received from concierge position of the petitioner. However, while arresting him on (2607-2024) in said Bongaigaon GRPS case number section 57 of to notice under section 50 CRPC was served upon the petition which the petitioner itself received on 2607. But the same is not in conformity with the provision of section 50 CRPC as well as the law laid down by the Honorable Supreme Court in the case. Right. And from the same, it is seen that the authorities of Bongaigaon GRPS while arresting the petitioner on 2607-2024 did not comply the provisions of section 50 CRPC. As such, and as such, violated the provisions of the people. Considering the law laid down by the Supreme Court in the case of and in violation and as the petitioner arrested in 2607-2024 violation of the provisions. Thereby violate the provision of the report is got. That's what I will say. Thank you. That's it.
Right.
Right, this is Lordship. Item number one, Lordship, regarding notice, Lordship, we have received the notice and they are not keen on appointing an advocate, Lordship. So my matters may be appointed. But here we are also on notice part, my lord.
But Mr. M. Kundaka Counsel appearing for the petitioner and Mr. PV, Mr. P. Sharma, additional possible appearing. On instruction, Mr. B. Sharma, our petitioner got prosecuted, submitted that notice of this bail application has been served upon the informant, upon the opposite party number 2, the informant of Manpasar PS case number 196 of the. However, the same opposite party number 2, the concerned informant, in spite of receipt of notice, did not appear it. In view of your vote, Dr. Pooja Agarwal. Be appointed as the amicus curiae for the sake of the party number 2, informant. All right. List on. Eighteenth.
My lord, may I put on 16, my lord?
116.
My
Let us see how many. Okay, it's 16.
I'm deeply obliged.
Map. Lordship, here in this case, Lordship, the petitioner was arrested on 24/10/2024, Lordship. And in NDPS case, Lordship, but Lordship, the averment is, Lordship, the section 47 and 48 is not compliant, Lordship. And out of 3 accused, Lordship, 1 already been granted by the coordinated bench, Lordship, page number 38, Lordship. Already granted, Lordship. And 47 and 48 is not compliant. And out of same FIR, same forwarding, Lordship, 1 is granted, Lordship. Page number 38, Lordship, order.
Actually, give it. Morning, police station, case number 74 of the 2024. Under section 22, in bracket C, or 29 of the NPKs, corresponding to GR number 1014. The basis of specific information. Deauthorization. Police personnel from Dubapara Police Post under Mornoi Police Station. On the intervening night of 22nd, 10/2024 and 23/10/2024. Intercepted a Tata Sumo vehicle bearing registration number WB-74-L-6427 in black color Tata Sumo. And also when they say vehicle along with these three persons, including the present two petitioners. When the said vehicle was searched in presence of independent witnesses and with the authorization. Some bottle cases wrapped with transparent plastic, suspected to be contraband drugs and DPS articles, were found in it. Total containing of 296 bottles of, each containing 296 bottles, each containing 100 ml of fancy diet, PHEN-SIPYR, cough syrup containing triploiodine, hydrochloride, iodine phosphate. The three persons of the said vehicle, along with the vehicle concerned, that was moved. They brought to the Mornoi police station. Along with the contraband goods found in the said vehicle. The three persons are arrested on 23/10/2024. Three persons, including the participant, and were produced before the Chief Judicial Magistrate Valpara on 24/10/2024. After the Mornoi police station, accordingly, Mornoi police station case number section 74/2024 under section 22, C of 29. Registered, they were arrested. So they took us. Since then, the petitioners are in custody. It is submitted by Mr. Hawk, counsel appearing for the petitioner, that a coordinate bench by its order to the 13/05/2025 already granted bail to one of the co-accused arrested along with the petitioners. Namely, Aslam Hussain, finding that the authorities of Mornoi police station, while arresting the petitioner, while arresting him, did not comply with the provisions of section 48 of the BNS. 47, 48. The petitioner's hearing submitted that they were arrested along with Said Aslam Hussain, who accused of the case, who has already been released on bail. Even in their case, when they were arrested on 24/10/2024, about 24. The police authorities of Mornoi police station did not comply. With the provision of section 47 of the BNSS. Without punishing grounds and reasons of their arrest. As such, Mr. Hawk submitted that the petitioners that they don't violate his bail. From the records of the case, it was called for It is seen that after completion of the investigation of the case, authorities of Monarch Police Station on 30/04/2025 submitted a search sheet in said Monarch PS case number such and such 74 of which is corresponding to PNR 101 under section 22 in bracket C of the 29 of the NTPS Act against the three accused persons of the case, including the present petition. After filing of the search sheet in said Monarch PS case number such and such, same was re-registered and numbered as special in bracket NTPS case number 07025 before the court of London special judge NTPS comes as judge per quarter. The search sheet confirmed. The FSL reported at 24/04/2025. Confirmed that the seized substance recovered from the conscious position of the petitioner containing of codeine. The contraband. Not pictures. The attachment is possible. It is also seen for that person pre-application of the concern investigating the London Special Judge NTPS by order dated 23/04/2025 granted further 180 days time. The concern investigating thereby extended the detention of the petitioner for some time. It is seen from the records of the case that Surge in sale. Special in bracket anti-case case number. The cognizance of the offense under section 22 in bracket C of the 29. Say that anti-case case number section 04062025. Charging the same, yeah. Great. From the record it is seen that to notice under section 47 BNSS where served upon the petitioners at the time of their arrest on 24/10/2024, which the petitioners have acknowledged, but in perusal of the same circumstances, it's found that same is not important. Then found. Then,
Deeply obliged, Lordship, obliged, deeply obliged. Obliged.
May it please your lordship. Lordship, respondent number 2 have entered appearance.
Lordship, we are appearing on behalf of respondent number 2, Lordship.
Service is complete.
LCR also received, Lordship. Kindly fix it for hearing.
what's your good name, ma'am?
P. Gupta.
On behalf of the petitioner. Ma'am, what's your good name?
AB Cast for respondent number 2.
Petition, petition to close the petition to the pertaining to. Okay. This criminal appeal was already admitted for hearing on 03/03 order. The registry has also received the records of their case number 360/2009 on the Court of Lorraine, Judicial Magistrate First Class. And the service of the is complete. Just the opposite. The records of the received. The registry shall list this matter for hearing. And it's with it.
May it please, your lord. So, my lord, in this case, my lord, so this accused appellant has been convicted under section 376. Conviction was 7 years, my lord, and he has been detained since the date of judgment till date little less than 6 years, my lord. all the records available before your lordships, and as such, the matter may be fixed for hearing, my lord.
Please take your seat. Heard Mr. Council appearing for the petition. The appellant. And Mr. P. Sharma, Learned Kitchen Person. Agreed by the conviction and sentence under section 376 APC. Dated 26/08/2019. Passed by Learned Edition System Calculating FTC. Kamruk Romia. In sessions case number 176 of the 2000. Sections case number 176 of the 2016. Rising out of Kamalpur Police Station case number 83 of the 2015. Corresponding to tier number 615 of the 2015. In which he has been convicted under section 376 IPC. He is sentenced to rigorous imprisonment for 7 years with fine of rupees 10,000. In default, to undergo simple remand for another 1 year. The appellant. Who is the appellant? The accused, preferred to see this appeal. This appeal was already admitted for hearing on 11/11/2019. And registry has already received the relevant records from the court of learning. Right. From the records of the case, it is seen that the appellant was arrested in said common two case number on 17/05/2015. And was later released after 3 months on 18/08/2015. Granting him default rate as the prosecution failed to submit the prosecution. Thereafter, the appellant is in custody, serving the sentence pursuant to the implement judgment that it has. Serving the sentence since 26/08/2001. Serving the sentence in terms of the implement judgment. Thereby, the appellant is in custody for about 6 years, 1 month, 14 days till date. As this appeal was already admitted and considering their vote, list this matter of hearing at the earliest. We will look at it for hearing on.
Your Lordship, may I fix a date, my last
we-
part of this month, my lord?
Would be possible, Lordship.
17th.
Make it.
17th is up. Already 6 years, 1 month, but left.
Anything, Lordship,
The bail prayer of the petitioner after filing of this appeal was earlier rejected on 19/01/20. Yes, what do you want?
Just a suggestion, Lordship, because Lordship vacations are coming, the last 2 weeks maybe. Maybe.
There will be some more courts.
But in his interest, Lordship, if it is fixed it after the vacation, the first week itself, it will be.
If it is not possible on 17th, it will be given. Otherwise, it will be futile appeal.
Yes.
That's what We have seen the records, otherwise we not have.
Much obliged.
May I please, Vinod? The petitioner may kindly be allowed to withdraw the appeal along with the IA criminal in view of the fact that a release certificate was issued by the jail authority revising his the remaining period and setting of the Hazard period and after getting 668 days of remission. As
You
per the
have the
release
order.
certificate issued by the jail
You
authority.
have the certificate.
This my lord, one copy is available with
Can you
me.
show it to the public prosecutor
Yes.
first, then we'll let us see it.
The certificate my lord issued on 17/5/2025. And he was already released from the jail. House.
Heard Mr. A.K. Jain, counsel appearing for the appellant. And Mr. B. Sharma, an additional prosecutor. Appearing for the state. This criminal appeal was filed by the appellant, namely such and such. Being agreed with the judgment and order of conviction and sentence dated 07/08/2019. Passed by London Special Judge. Put in bracket, POCSO. Karbi Angla. At Tipu. In POCSO case number 24/2018. In special. Case number 24/2001. Special case number 38, special case number 38/2018. Arising out of Mocha Police Station case number 38/2018. Corresponding to GR number 803/2018. Whereby the appellant was convicted under section 363 IPC reduced section 4 of the PSUSU Act. And sentence him with rigorous imprisonment for 6 months under section 363 IPC. And rigorous imprisonment for 8 years. With fine of ₹1,000. In default, sinful imprisonment for 2 months. Under section 4 of the PSUSU. This appeal was admitted for hearing. Not yet. Okay. Appeal was admitted for hearing on by order dated 012/02/2021. In the records of said such and such was called for. During the deliberation of the matter, Mr. Zain learned counsel appearing to the accused appellant. Placed a copy of the release certificate issued by the jailer of District Jail Tipu dated 17/05/2025 certifying that the present appellant was convicted for 8 years rigorous imprisonment with fine of rupees 1,000 in default simple limit of 2 months in connection with POCSO case number 24 of 2018 arising out of police station case number 38 of 2018 has been released on 17/05/2025 on expiry of sentence, comma, payment of fine, comma, setting of the hazard period, and on getting 668 days remission. As such, Mr. Zain Lanet, counsel appearing for the appellant, prays for withdrawal of this appeal along with the interrogatory application being IA criminal 176 of 2021 filed along with this appeal. As the appellant has already served the sentences to which, dear, noted, to which Mr. P. Sharma had supervised no objection. Accordingly, this criminal appeal on appeal being stands closed. I separately in view of the other part of this being in purpose. The copy of the communication dated 17/05/2025 of the Taylor District People placed before the court today by Mr. Zain Lanet, counsel for the accused appellant, pertaining to the release of the appellant on 17/05/2025 in said POCSO case number 6, be kept as a part of the record. Registry shall return the records of Special Judge POCSO case number 20, records of POCSO case number 24 of 2018. Special case number 38 of 2018, bracket close, arising out of Tokmoka Police Station case number 38 of 2018, corresponding to GR number 803 of 2018, to the court of Lanet, Special Judge POCSO, Karbi Anglo, the proof, along with a copy of this order and photocopy of the release certificate noted above, issued by the jailer, District Jail Depot, dated 17/05/2025.
Metro law.